right. So good morning, everyone. Thank you again for being here. My name is Tony Dalimonte, and I get to talk about the fun stuff, robots. I get to talk about artificial intelligence, how employers are using it, and the law you should be aware of. So we've got a lot to cover in a short period of time, so let's get started. What is artificial intelligence? It sounds complex, sounds like the robots are taking over, the Matrix, Terminator. But what artificial intelligence is at its essence is computer systems that are able to perform tasks that normally require human intelligence. And AI has become really popular. It's in the news over the last year with the emergence of ChatGPT, but it's been around us for a long time now, just in less, sort of obvious ways. For example, Google Translate uses machine learning to, translate languages. Netflix uses algorithms to give you recommendations. And, if someone watches a TV show on your account, it messes up with your algorithm. And Tesla obviously uses artificial intelligence for self-driving features. They use computer vision and machine learning for all of its technology. And the EEOC actually provides us some helpful definitions on some of the stuff to help give us a framework of what we're really working with here. So they define software as, technology that provides instructions to a computer on how to perform a task. An algorithm is basically a set of instructions. And artificial intelligence, according to the EEOC, is a system that is given a set of human-defined objectives that can make predictions, recommendations, decisions affecting real life. And machine learning is a computer's use of algorithms or rules to learn and adapt with experience. So, now that we've got sort of the definitions down, what's the big deal? Well, businesses, as you know, and I'm sure, a lot of you have incorporated AI into your business, they're increasingly relying on artificial intelligence in their employment practices, and that's what we're going to talk about today. So what's the concern? The concern is that there's a potential for AI software and algorithms in AI to discriminate. And we know that AI is being used in workplaces, and the EEOC has actually come out and said that 80% of employers are using AI in some fashion. And so how is it being used? We know it's being used in recruitment, in hiring, employment decisions, onboarding, monitoring, automation, which is like the chatbot on websites, and performance management. And, in many ways, AI is a great tool that can make things more efficient, but it can also lead to some landmines and get you in trouble if you're not careful. So what are the laws that regulate artificial intelligence? Well, existing state and federal statutes, related to labor and employment law that, we've been talking about today and you're well aware of, these all still apply. So Title VII, the ADA, the NLRA, the ADEA, they all still apply. But has anything changed? The enforcement of these federal statutes, has changed a little bit in that federal agencies have come out and said that they're paying really close attention to artificial intelligence, machine learning, and, all of these emerging technologies. So the EEOC, the DOJ, the Consumer Financial Protection Bureau, and the Federal Trade Commission, sent out this statement basically highlighting their concerns that artificial intelligence could impact civil rights, it could impact equal employment opportunities, competition among businesses. So, the federal agencies are paying attention. In terms of what state laws apply, we don't have a specific artificial intelligence law in Michigan yet, and states around the country are, proposing laws left and right to address some of these concerns, especially in the employment arena. But interestingly, New York City has become sort of the gold standard for artificial intelligence law right now related to recruitment and hiring. And we think a lot of states are going to follow suit. And so, back in July, so just a few months ago, New York City implemented local law 144, regulating the use of automated employment decision tools, or AEDTs, in hiring, and restricting the use of AEDTs by employers and employment agencies, requiring that these tools be subjected to bias audits, and requiring employers to notify employees when these tools are being used. So in New York City, before an employer can use an AEDT or any of these sort of artificial intelligence tools, such as a resume screener, it must conduct a bias audit by an independent auditor to assess the tool's potential for disparate impact on race, sex, and ethnicity. Not only that, so they have to conduct the audit, but the employer also has to publish the results of the audit on its website. And when an employee or a candidate applies for a job, they have to, very clearly provide the candidate with a link to that most recent bias audit, at least 10 days before using such a tool. So 10 days before an interview, you have to send them a link saying, hey, here's our most recent bias audit, and sort of give them that information. So what are some of the legal issues that can arise with using artificial intelligence in your business and in your employment practices? Discrimination from algorithm bias can result in disparate impact. And I'm going to talk about that more in detail in just a minute. But there's also risks of disability discrimination. There's cybersecurity concerns, privacy concerns, and making sure you protect your trade secrets and confidentiality. So as I mentioned before, federal agencies and the EEOC in particular have really drawn focus on artificial intelligence and this emerging technology as an area of concern. And they've identified that AI can cause violations of Title VII. And they've actually issued formal guidance on their website to employers that sort of addresses where they see employers can get in trouble by using AI. And this guidance focuses primarily on the fact that using AI in recruitment and hiring practices can result in a disparate impact discrimination, which violates Title VII. So they say that if an algorithmic decision-making tool or an AI tool has an adverse impact on individuals of a particular race, color, religion, sex, or national origin, then that tool will violate Title VII unless the employer can show that such use is job-related and consistent with business necessity. And, one really important thing that the EEOC focuses on in the guidance is that employers are on the hook and responsible for tools developed by third-party software vendors, not the vendors. So, you run a business and you go and contract with a software vendor to provide you a resume screener or some sort of hiring software. You're the one that's on the hook, not the vendor. And so it's really important that you as the employer are really engaged in that process of vetting a vendor, making sure that any software that you use in your business, you're doing everything you can to find out whether or not there's going to be a disparate impact. You're asking questions of the vendor, potentially asking if they've conducted a independent bias audit. Basically the employer needs to be the one that's intimately involved in that process. And, to figure out whether or not an AI tool results in a disparate impact, the EEOC uses a 4/5 rule to help guide whether or not a selection procedure results in disparate impact discrimination. And I won't go into too much detail on it, but the 4/5 rule, if you're not familiar, is a process for determining whether a selection rate of a particular group is less than 4/5 of the rate of a non-protected group, then that selection procedure can have an adverse impact. So, the types of AI that the EEOC is focusing on, they're looking at resume screeners, video interviewing software, testing software, and chatbots. And by way of example, Years ago, Amazon actually started developing their own machine learning recruiting tool to try to make things more efficient, as they do. And they wanted a system where, if they receive 100 resumes, the AI tool will spit out the best 5 and they can go hire those best 5 and they don't have to, engage in the hiring process as intimately. But they actually had to scrap the project because an audit of the tool showed bias against women and found that, in effect, the system taught itself that male candidates were preferable. The tool found that candidates were more favorable. Candidates that used words such as, executed and captured, words more commonly found in male engineer resumes. The tool actually favored those individuals and actually penalized resumes that used words like woman's or women's chess club or women's, soccer captain, and it downgraded graduates. It actually downgraded graduates of 2 all-women's colleges. So again, Amazon's ended up scrapping the whole project. And just a month ago, we've actually seen our first AI class action settlement. This online tutoring company, iTutor Group, they entered into a settlement agreement with the EEOC for violations of the ADEA while using a resume screening tool. And so what happened was they were using this tool, and an applicant submitted 2 applications that were identical except for one detail, her age. And on one application, she used her real age, and on another application, she used the younger age. And she was actually contacted for an interview based on the second application with the younger age. So the EEOC caught wind of this, filed a lawsuit on behalf of over 200 applicants, and they ended up settling the case. But as part of the settlement, to underscore the importance of this, they required the company to adopt new anti-discrimination policies, conduct trainings. They had to invite all previously denied applicants to reapply, and they had to cease requesting birth dates as a sort of element of resume reviewing. So in addition to Title VII, the EEOC has issued another guidance for employers related to AI and potential violations of the Americans with Disabilities Act, and identified 3 ways in which an employer's use of AI can violate the ADA. First, if an employer fails to provide a reasonable accommodation to an applicant who needs an accommodation to be fairly rated by the algorithm or the AI tool. So, for example, if an applicant has to watch a video as a part of the interview process, a visually impaired applicant should be given the opportunity to request and utilize an accommodation. Second, the EEOC tells us that there's a risk of screening out individuals with a disability while using an AI tool, even if the person is able to perform the job with an accommodation. So if, for example, if someone has gaps in their resume and an AI tool screens out those resumes without giving the individual an opportunity to explain why those gaps exist, you could be screening out someone because of a disability that they had during those gaps, or a pregnancy, for example. And third, the EEOC tells employers that you can get in trouble with the ADA if the AI tool makes disability-related inquiries or medical examinations. So the employer cannot use an AI tool prior to making an offer of employment if the tool is going to, identify candidates' medical conditions or ask medical-related questions. And the EEOC gives us a few recommendations on how to stay compliant with the ADA, and they recommend that you have a process in place to allow applicants to request an accommodation when using AI tools, and to vet those tools to ensure there's no, medical-related inquiries. So that's the EEOC. What about our good friends over at the NLRB? What do they have to say? Well, the General Counsel issued a memo stating that the use of AI can violate the National Labor Relations Act if, a bunch of things result from use of the AI. So, for example, if the underlying algorithm is making decisions based on an employee's protected activity, or AI is being used to screen job applicants or issue discipline, or if AI is being used to, apply production quotas or efficiency standards that, have the effect of ridding the employer of union supporters. These are all sort of examples that the NLRB is looking at and their concerns with this emerging technology and potential violations of the NLRA. So you might be saying to yourself, we don't use AI in the business. Why do I care? Well, we know that employees are using AI at work, and usually without their bosses knowing about it. A Business Insider survey found that 40% of professionals have used AI like ChatGPT at work in some capacity, and 70% of those people did so without telling their bosses. So there's a few things you should be concerned about with employees using AI, especially, without your knowledge or without a policy in place. There's concerns about confidentiality, trade secrets, cybersecurity, and just plain inaccuracy. And I'm sure you've heard about the story with the New York lawyer who used ChatGPT, which gave him a fake case, and he used that case in a brief, and he was pretty severely reprimanded by the court and issued sanctions as well. So, we know that ChatGPT is not always accurate. It's programmed to give you an answer and not necessarily the right answer. So something that we're recommending to our clients is to develop an internal policy that addresses use of AI or AI-related tools within your business. Some things to consider when you're developing such a policy is the level of AI use that you want to permit. So are you going to issue a blanket prohibition across the board, or are you going to, implement a policy that's somewhere in the middle using some guardrails? And some things to consider when drafting an artificial intelligence internal policy are your data privacy and security considerations. For example, employees shouldn't be entering private or personal information into any AI platform or having conversations, with ChatGPT, for example, using some of this private information. Confidentiality is another concern. Again, with ChatGPT as the example, employees shouldn't be entering your confidential information or trade secret information into a conversation. There's copyright issues. So there's AI tools out there that can make really cool sort of advertising mock-ups for you, but you need to make sure that the content received doesn't violate copyright laws. And, the big thing is you have to make sure that employees are aware of the consequences of using AI, and that they could potentially face repercussions for, using inaccurate information, as a result of AI or improper use. So, that's the policy portion of it. And, if you are using AI in your business, conducting AI training is something that, you might want to consider. And to quickly wrap up with a few recommendations, be an active decision maker. AI can be a helpful and, let's see if I can go back one. Can't go back a slide, but you can look at Cliff's beautiful face. To wrap up, the main takeaway is be a really active decision maker if you're going to use artificial intelligence in your business. You should actively oversee your AI-driven processes. The employer, and more specifically a human, should always be the final decision maker. Regarding using vendors, again, you want to make sure that, you're vetting these tools, you're asking the right questions, you're asking whether or not an independent bias audit has been conducted, and what steps the vendor has taken to remain compliant with Title VII and the ADA. And transparency, in Michigan, you're not yet required to disclose to applicants whether or not you're using an AI tool in hiring, but we think that's something that will likely change. So something you should consider. And if you're concerned about, a tool you're using and the potential disparate impact, we recommend potentially conducting an independent bias to evaluate the impact of your tools. And that's it for me. Thank you again for being here this morning. If you have any questions, feel free to reach out to me, and I'm